Hey everyone, Joe Concepcion, the Heartland Defender here. I'm a few days late to the party, but apparently Megyn Kelly set the internet ablaze this weekend with comments about barely legal teenagers and how sexualizing or fetishizing a 15-year-old is not the same as being a child molester. And this is a problem. I never thought that I'd hear a journalist in mainstream media that wants to be taken seriously ever use the term barely legal in an unironic sense. I thought we agreed on this as a society. We don't sexualize children. 15-year-olds are children. And talking about a 15-year-old and calling her barely legal or justifying or rationalizing that she's somehow fair game for a sexual gaze is just wrong. And if you think that way, you're a pervert. Now, mandatory viewing before we go into this video is my last video about due process and how I sleep at night and why I believe in what I do. And none of that is mutually exclusive to me sitting here and saying I don't condone sexual abuse. I don't condone the sexualization of children. Now, before any of you come at me with but actually, ephebophilia, look, man. 15-year-olds are 15-year-olds, okay? They're barely out of middle school. They shouldn't be sexualized, much less by a grown-ass adult, especially not by an adult in middle age. They're sexualizing children are major offenses. We're going to talk about the law on that today, and ultimately, although this is connected to our political discourse, this is not a political rant. This is a talk about what the law is. And it's also me bitching about the fact that we don't sexualize children. It's just wrong. I thought we agreed on this as a society. And if anything, it's a rant against the baseness of our public discourse, that we've got otherwise intelligent adults using the term barely legal to describe a 15-year-old unironically. That's just wrong. Now, what qualifies me to talk about this? What makes me an authority? Well, I'm not claiming to be an authority, but I think I know a thing or two about the topic. I've been practicing for 26 years. 25 years of that has been in criminal defense. I made my career going to trial frequently on the most serious offenses, including many homicides and non-capital homicides, non-death penalty homicides, and sexual offenses, sexual batteries, lewd offenses, etc. And that's also included juveniles. When I was a prosecutor, part of my job included prosecuting juveniles for sex offenses. There were the occasional cases that caused me some reservation about why this is criminal, if it's just sexual experimentation coming of age among peers. But that's not what we're talking about here. We're talking about people who abused a situation or where there was a significant age difference. And even as a juvenile, that's treated very seriously. One of the things I did while I was a prosecutor, I published an article on pre-adolescent sexual offenders and discussing how we can stem the tide of recidivism to keep those pre-adolescent sexual offenders from becoming adult offenders. So I know a little something about the topic. Now, before I get started on the rant too much, defending people, ensuring their due process is not condemnation of their behavior. Condemnation of behavior that you're going to hear me speak about today, the condemnation about the sexualization of children, does not compromise my ability to do my job in any way, shape, or form. So don't come at me for that. So what's the law in Florida? Well, there's different offenses. There are lewd batteries, which are sexual contact with someone 16 or 17 and the perpetrator is over 18. Now, before you aha me and go, 16 or 17, that's not 18. Look, man, it doesn't apply. The idea of having sex with a 16 or 17-year-old really applies to people who are 16 or 17 themselves. There's in fact an offense called sexual contact with a minor, and if anybody over 24 has sex with a 16 or 17-year-old, that's a felony. So, sexualization of minors, no matter how you want to play it, no matter how you want to spin it, is a felony. whether it's contact, whether it's sex, whether it's penetration, whether it's molestation, whether it's exhibition. These are all felonies. We don't sexualize children. And of course, there's the big kahuna, the sexual battery on children under 12, or lewd batteries on children under 12, and that's always a first-degree felony, punishable by life. If someone is charged with a sexual battery where there's some aggravators, such as damage to the child's sex organs or any other trauma like that, that could aggravate it and cause it to be a death penalty offense. Bottom line, these are very serious offenses. And just because child molestation, as we recognize it, for someone under 12 is so very serious, doesn't mean that contact with a child that's not under 12 is any less serious. We don't sexualize children. A 15-year-old, how can someone with kids say a 15-year-old is barely legal when a 15-year-old is barely out of fucking middle school? So I thought we agreed on this as a society, and I'm disappointed to see that the level of our public discourse has reached the point where someone in legitimate, recognized media is trying to unironically use the licentious porn marketing term barely legal to rationalize the sexualization of fucking children by grown-ass adults. Is that really where we are?